4, 3, 2, 1.
This Honorable Court of Tennessee is now in session.
Thank you, Ms. Kraft. And on behalf of Judges McGee and McBrayer, let me welcome you to the Court of Appeals. This argument will proceed just as if we were all together in a courtroom. And hopefully there won't be any technical glitches, but if there are, Mr. Jacobson will take care of them, and we'll just pause till he does. If there are no questions or anything, let's call the case, Ms. Kraft.
Is Suzanne R. Vance versus Sally Ann Blue et al.
Okay, let's see, the appellant, Mr. Maness.
Thank you, Your Honor. I have asked to reserve 5 minutes of rebuttal time.
All right.
Please, the court, I'm Roger Maness. I represent the plaintiff, Suzanne Vance, in this partition case involving a house and lot in East Nashville. The parties in their pleadings both sought partition and stipulated at the time of trial that the property could not be partitioned in kind. The trial court found that Ms. Blue had purchased this property and had gifted a 50% interest with right of survivorship to my client, Ms. Vance. The parties at that time were living in a domestic partnership relationship and operating a sandwich shop over on West End and owning a bought this, or Miss Blue bought this house over on in East Nashville. The trial court found 50% interest, and in the brief of appellee, there are two important references that I would like to call the attention of the court to in the brief of appellee. Well, the first one would be that there's a footnote on page 6 of the argument in the brief of appellee, in which it appears to me, at least, that Miss Blue has conceded this issue. The 50% ownership interest gifted by Miss Blue to Miss Vance, and did not seek to appeal that or reverse the trial court's finding in that regard on appeal. It's a footnote on page 6 of the brief of appellee. The other reference that I would like to direct the attention of the court to is a sentence that overlaps pages 3 and 4 of the argument of the brief of appellee, in which it is asserted that Miss Vance only has to compensate Miss Blue for Miss Vance's share of the cost in connection with this property. So there was some confusion, I believe, resulting from the trial court's opinion. It looked to me like the trial court assessed both Miss Vance's cost and Miss Blue's cost against Miss Vance in the matter. And the clear authority of this court in Parker v. Lambert, Judge Frank's opinion, is that co-tenants are each responsible for their half of their share, respective share, of, in this case, a half of the cost of maintaining the property, which would include, in this instance, a mortgage obligation or obligations. And
wouldn't it also include insurance and property taxes?
Yes, it would include taxes, property taxes, and insurance also.
And the court's order really doesn't account for either of those items, does it?
Does not. Well,
so we don't know what Miss Blue paid for those. I mean, she would be entitled for credit for those. Wouldn't you agree?
I agree that she would be entitled to credit for mortgage payments that she's made, taxes, insurance, and some necessary repairs and maintenance. Now, that there is case law to the effect that they don't get compensated for improvements, money spent on improvements, unless unless it's demonstrated that the improvements actually increase the value of the property. And there's no evidence of that in this case on it. course, this property is in East Nashville, and property in Davidson County is appreciating at an incredible rate, and has been for a number of years on it, with or without regard to, in a lot of cases, its condition. But in answer to your honor,
I mean, you know, people that live in and around Nashville, I guess, can take notice of that. But was there any actual proof of that offered at the trial?
I don't believe there was.
I mean, I think didn't Miss Blue give the only really evidence of value?
She did. She gave the only evidence of value. It was based on it was essentially hearsay. She testified that the property had been appraised at $435,000.
But right, but I think she also offered her own opinion as to the value of the property.
Well, the trial court restated the question for counsel, and she did offer her opinion as to value on it, and she's entitled to do that, I believe. On it. But I'll address that momentarily. I mean, I want to answer your honor's questions as best I can on it, but in my mind, and the approach we took on it was that there was, after the parties had stipulated that the property could not be partitioned in kind, the inevitable result from that was going to be a sale. And so it wasn't really necessary to prove the value of the property, because a sale would determine the value of the property on it. And in this case, we think a public sale is the correct way to go on it, because of the uncertainty of the market over there. But the case law that we have submitted, the estate of battle case, in my mind, makes it clear, a recent opinion from this court involving very similar circumstances to this case, that the trial court cannot simply assign a value to the property and order one of the parties to buy out the other. That does not comply with the statutory requirement for a sale in lieu of in a situation where the property cannot be partitioned in kind. So that's a 2017 opinion out of this court, derived from Davidson County Probate Court, Judge Kennedy's court, and it seems to me to be directly on point on it. So after the brief of appellee, the provisions that I read, it seemed to me that this court is confronted really with two questions. One, is Miss Blue entitled to a credit for half the purchase price? The Rivkin against Postal case that we've cited, I believe, weighs against that, in as much as there was clear intent to make a gift here. The trial court so found, and there's been no appeal of that finding. So she should not respectfully get credit for half of the purchase price, which is $235,000. Well, the total purchase price is $235,000. So half would be half of that, 117.
Yeah, I'm not sure I follow the logic in that though. She gifted a half interest, but you're saying she only gets credit for half the purchase price?
She doesn't get credit for any of the purchase price.
Any of the purchase price?
Any of the purchase price.
Okay.
Because a gift is a gift. And once she paid for it and made a gift of a half interest in it, that gift was gone, essentially. And that's the holding of this court in the Rivkin against Postal case. Similar set of facts, domestic partners. And so our position is, and I think it's backed up by the authority that we've cited in this case, that she just doesn't, that once she made that gift in 2005, I believe, then that was a gift given and a gift gone, if you will. And she at that point had given away a 50% interest with right of survivorship in the property. Now, it's not surprising that you get several years down the road and acrimony begins to manifest itself between these parties, and you all of a sudden, what started out as a gift is not a gift anymore. It's sought to be retracted. So I'm running out of time on my first 10 minutes. It always gets away from me a lot quicker than I expected it will for some reason. But the other question was, and I think I've addressed that already, is does this property have to be sold? And the opinion of this court in the case of in re estate of battle seems to me to be decisive on that issue, that there has to be a sale in this case on it. So I'd be happy to try, and I got 27 seconds left. I'd be happy to try and answer any questions that.
Well, what about your issue 2, your client's recalcitrance about appearing for a deposition in the suit she filed?
Well, first of all, there's a misstatement in the brief of appellee. She didn't file the case and move to Chicago. She was already in Chicago. She'd been in Chicago since 2015. And we filed the case based upon my experience in these cases and the rule as adopted by the Supreme Court regarding telephonic depositions. It seemed to me to be an appropriate case for a telephonic deposition. And it was transparently obvious from the very beginning that this was an effort to try to force her to come to Tennessee so that she would be arrested on it. We were working on, through a different set of lawyers in Nashville, Davidson County, straightening out her legal proceedings. Counsel announced to the court, counsel Ms. Blue announced to the court that she didn't see any need to take depositions in the case. And then later used as a pretext for essentially successfully compelling my client to come to Tennessee and give her a deposition, the fact that we had not answered requests for admissions under oath. Well, they're not required to be under oath, and they haven't been for many, many, many years. So that was a pretextual basis for that. It was obvious that at that point it was an effort to force her to come here to result in her arrest. And ultimately, she presented herself to the General Sessions Court in Davidson County and resolved those matters. Actually did some jail time down at the Harding Road facility. Got all that behind her, presented herself for a deposition in person, and then attended the trial in person. So, but it seemed to me that if there were ever a case that would be appropriate for a telephonic deposition, it would be this partition case. And there just really wasn't any reason not to do that. Most partition cases proceed without formal discovery at all. At all. Most of the time, there's a hearing before the clerk and master, and the clerk invites everybody in, and they take hear from the parties, anybody else that's material to it, and there is no formal proceeding. The clerk renders a report and recommendation, and the trial court either accepts it or not. Parties
Mr. Maness, your time is up.
All right, John.
Well, thank
I'm
you.
trying to answer Mr. Judge McBrayer's question.
Yeah. Was it answered, Judge McBrayer?
I believe it was.
Okay, thank you. Ms. Rubenfeld.
Thank you, Your Honor. Good morning to all of you. I'm Abby Rubenfeld. I represent the appellee, Sally Blue. Let me start by responding about the deposition. Your Honor's read the facts. We had to go to extraordinary efforts and my client had to pay a lot in attorney fees just to get the deposition of the plaintiff in her own case. And it's a gross misstatement to say that it was patently obvious that this was a subterfuge to try to get her arrested. The fact of the matter is the facts in this case, many of them were disputed, and I did need to take her deposition. I mistakenly assumed that she would answer admissions and that would obviate the need, but the admissions were answered by her attorney, which is allowed. I don't know why I didn't anticipate that. But so I did need to take her deposition, which is our right in the case. And it wasn't a burden to her. It was her case. It's her own fault. She had criminal charges. That wasn't our problem. And she admitted that she could have come back to the state at any point to take care of the criminal charges. It was her own choice, A, that the charges were brought, and B, that she hadn't resolved them by then. I mean, the testimony showed that she had violated her probation here and then fled the state to avoid going to jail. So it doesn't seem to me that my client's ability to defend the case and to pursue her own case for partition has to be limited because of the plaintiff's intentional bad behavior, which is basically what she's asking. The court had discretion to do what it did, and the appellant has not really cited anything that fits within the statutory requirements for an abuse of discretion. There's no injustice by applying an incorrect legal standard. They're not even arguing that. It's not an illogical result. It's not resolving the case on clearly erroneous evidence. It's not based on reasoning that causes an injustice. And the standard is that abuse of discretion, if the court has to find that there's no possible way that the ruling could be upheld, and reasonable minds can disagree, I suppose, since I think Mr. Maness and I are reasonable, and we disagree on that. So I believe that that's really not an issue. We had to go through a lot, and my client's entitled to recover back for that. And I also want to clarify something. The statements in our brief have to do with the 50-50 finding. We dropped our opposition to a finding of 50-50. We're not dropping our opposition to whether or not that was a quote gift. And I don't believe the trial court opinion finds that. It talks about it being a gift, and it talks about if it isn't a gift, that either way it doesn't matter because of the evidence of my client saying she filed a conservatorship action and stated in that it was 50-50. We're bound by that. But I don't agree that it was a gift. The only testimony about an actual gift was from my client saying she did not have the intent to gift it. And I think the argument that this property, for which Ms. Vance paid zero, she paid nothing for the original purchase, she paid nothing for the mortgages, she paid nothing for the taxes, she paid nothing for the insurance, she paid nothing for the repairs. And we put on proof of all of that Ms. Blue paid. In fact, it was not contested by Ms. Vance. It's undisputed that Ms. Blue paid for everything. And the findings of the trial court did not include anything about improvements. We put on proof of some improvements that Ms. Blue made at her own expense. And there was proof, undisputed, that the parties kept their money separately. This is not a married couple. Shoot, I just had a senior moment and lost my train of thought.
Well, let me help out then. Can
Good
we
opportunity.
Yeah. Let's go to the first issue then about the remedy that the court ordered here in terms of the partition. Your position is the court has vast discretion here. I'm concerned about a state of battle and the Yates case, which seems to me to dictate that there has to be a public sale of some sort.
Yes. I'm sorry. Are you finished?
Yes.
I'm concerned about that as well, Your Honor. But I think that Yates is distinguishable from this case, and that we are reading a great deal into the findings that aren't necessarily there. And if this court thinks they are, then I would submit that it's time to revisit the Yates finding. Factually, Yates is extremely different than this case. The holding, first of all, was that the relief granted by, well, that's a case where the pleadings weren't done very well, I think. And the relief granted by the trial court was beyond the scope of what the both parties had sought. So it was vacated and remanded with authority to determine the party's interests. So it's different factually, and I think that was the holdings. There was no findings as to who had paid what, who had what interest. Significantly to me, the property at issue in that case was worth $35,000 with an indebtedness of $16,037. So we're talking about something that there's much less money at issue. And there's nothing in that case to suggest that it was as one-sided as this case is. This is a court of equity, and ordering a public sale of this property so that my client loses her home that she alone has paid for. The court found that she paid for it twice. So ordering a public sale of that, where she will either basically lose her home or pay for it a third time, and Miss Vance will get a substantial windfall when she invested zero in this house. And it's also significant that during the entire time the house was owned, until 2018 at least, Ms. Vance not only didn't contribute to the house, but she was paid a salary from a business that she didn't help purchase. This is all on the record. She paid nothing for the purchase of their jointly owned business, and she didn't work there, but she was paid $2,500 a week, not a month, not a year, $2,500 a week until just a few years ago, or a few years before the case was brought, when it was reduced to $1,800 just because cash flow had gone down. This was a very successful Jimmy John's franchise. There's no doubt about that. But my client not only worked there, she got a salary too, but Ms. Vance got a salary, got her health insurance, got her cell phone, all paid for, and did nothing for the business. So the Yates case, there's nothing to indicate it's nearly as one-sided as this case is. And there's no discussion of equities in that case. In this case, I mean, most basic principles of equity are violated by the idea of a public sale. She who comes to equity must do equity. I mean, that is not, it's not equity by any stretch of the imagination. So yes, it's not really a holding, but the comments in Yates don't help us. I certainly agree with that. And I see that, I agree that's a problem, but I think the case is distinguishable, and trial courts do have discretion to craft a remedy. And in this, there is nothing in the statute itself that requires a public sale, nothing. That this is extrapolated from, I don't know, from some of the cases like Yates, but there's nothing, no statutory language that requires that. And indeed, the statute, the statute requires, I tried to write it down so I wouldn't have to do this. The statute does include language about a sale that, I mean, it's not exactly on point, but subpart 2 of section 201 does say that the sale would be manifestly for the advantage of the parties. And this sale would be manifestly to the advantage of Miss Vance. A public sale would be. In fact, it would be an incredible windfall to her to receive that. The way the trial judge found it, based on the equities, was to determine the half that Vance owed based on the value that the court found. And in that way, I also think it's different than Yates, because there was undisputed evidence about the value of this property. Both parties had the same opportunity to put on proof of value, but only Blue did. And Vance didn't contest that. She didn't object to the value. So it's undisputed that my client's opinion on the value, and I don't believe the judge asked the question, I believe I did. When they objected, I reworded the question, although I don't think it matters. She's entitled to give her opinion about the value, and she did. It's her home, and she said $435, which is consistent with the tax appraisal, which we introduced without objection. They didn't object to that being introduced. That is the value. And I don't believe that was done in the Yates case. But based on that value, and based on half of the initial purchase price, which was not a gift, if there was any gift, it was to put her on the property title so that if something happened to Miss Blue, her partner would be protected, since at the time they weren't allowed to marry.
Well, and I guess on that point,
Yes, sir.
we'll have to look at the record, but so Ms. Blue's position is this was really an estate planning
Yes, sir.
point, but then that sort of misses the obvious point, is that Will would have done the same thing for her here, which sort of militates against the finding that it was just estate planning.
I understand, Your Honor, but Miss Blue isn't an attorney, and I don't think she knew the difference of how you handle that. I mean, she was trying to do her best with what she understood to be limited law, and that was her intent. There was no, I don't believe there was any testimony about other options and if she considered them or if she got legal advice. She just testified, and it wasn't challenged, that that's what she intended to do. And she testified to that consistently at her deposition. One of the days that Ms. Vance decided not to show up for a properly scheduled deposition, Mr. Maness did get to take my client's deposition, and she was very clear about this particular point. I believe that the finding of the chancellor is overly generous to Ms. Vance, because based on the figures that were proven at trial and no objection was made to them. In addition, like if Ms. Vance owed half of 435, half of 180, the first mortgage, which was used for the Jimmy John's business, and to pay $20,000 to $30,000 of Ms. Vance's separate debt, and the second lien of $79,500, that right there, her half is more than the current value of the house. So based on those figures, she would owe my client $31,000. So the court finding that she gets some payment is basically a gift to her. I mean, it's what she's asking for is just completely inequitable. And there's also case law that says, most of the cases say that each should get their own in a partition. And the proposal that this simply be sold at a public sale just means my client loses all of her interest. Basically, she's already paid for the house twice. And what we're proposing is allowable, I believe, with the the discretion of the court, and based on the very clear equities in this case and the extreme one-sidedness of those equities in this case. Let's see, I'm seeing what else I wanted to say real quick. There was no proof at trial, none, about increased values in East Nashville or Nashville. Mr. Maness said that, but there was no proof about that. It wasn't even asked for the court to take judicial notice, nor did the court take judicial notice. The only evidence of value was what we put on. And as I said, the tax appraisal was introduced without objection.
But both parties agreed, though, here that partition in kind is not suitable here. It just does not work.
Yes, sir. That is true. It's a house, and
so it has to be a sale. It's just the argument is what sort of sale is required.
Yes, sir. And my position is the statute does not in any place say that it has to be a public sale or an auction sale, and that the trial court has discretion to craft a remedy that meets the equities of the case. And if your honors hold that Yates is against that, then I'm submitting that Yates should be reassessed, given the passage of almost 50 years, changes in the law, and the extreme difference in equities in these cases. Thank you.
Thank you, Ms. Rubenfeld. Mr. Maness, you have your rebuttal time.
Thank you, Your Honor. When I started out practicing law in 1980, cases that had been rendered what are now 50 years ago seemed fairly recent in vintage. But so I don't know about the 50-year comment on it. I say that in tongue in cheek. Ms. Rubenfeld and I are about the same age, I think. So I may have a few years on her, but a couple of things that I want to note about the case law here. One is that we raised in our brief of appellant the Battle case, in re estate of Battle case. It was ignored in the brief of appellee. I brought it up again today in argument, and Judge McBrayer mentioned that he was concerned about it. And now, after 15 minutes of argument, Battle has not been addressed by Ms. Blue in this case. It stands for what it stands for. And it's a case of very recent origin on very similar fact patterns, different parties for sure, but an assignment of value by the trial court held not to be appropriate, and the trial court ordering one party to buy out the other based on a percentage. In this case, the irony is that the percentage wasn't at 50%, it was at 5%. So I want to address that because, and briefly, Yates, of course, is a Tennessee Supreme Court opinion, and with all due respect to this court, in front of whom I have argued more than any other court probably anywhere, including many trial courts, because you know I do a lot of appeals, but this court simply doesn't have the authority to revisit an opinion of the Tennessee Supreme Court on a matter or reverse an opinion. Now, certainly this court could say that the facts of this case are distinguishable in some respects from Yates, but Yates can't be revisited in the sense of the essential holding on it, unless that's done by the Supreme Court itself, with all due respects. So the appeal to equity is and I say this tongue in cheek. I used to hear that the appeal to equity was the last refuge of a scoundrel. And I say that I like Ms. Rubenfeld, and we're colleagues and all that, but the appeal to equity does not work in this case standing alone. And the reason for that is equity, how a trial court assesses the equities between the parties in a partition case like this has been prescribed by this court in a reported opinion written by Judge Franks and Parker against Lambert. And trial courts are not vested with unlimited equitable discretion in sorting out the equities between the parties. And a judge in that case, in that opinion, it's laid out step by step how the process occurs. And that's essentially what we're asking happen in this particular case. And I want to address one thing that regarding this gift issue. Who would have expected Miss Blue to take any position other than the one that she took once this partition case was filed? I didn't intend to make a gift of it. But her testimony, unequivocal testimony, was I set it up this way. I paid for it, and I set it up this way so that if something happened to me, Miss Vance, my client, would have a place to live on it. So, and I presented this hypothetical to the trial court.
Well, let me stop you there, though. I want to make sure I'm clear here on what the court found. Did the court actually make a finding that this was a gift such that you could ignore the down payment on the home? Or did the court just leave that, say, look, it doesn't matter either way, this is what I'm ordering as the partition by sale?
I think the latter is the answer to the question on it. The court used language from which anybody could conclude, I believe, that a gift was intended, but didn't really address that issue.
Didn't make that finding.
Head on it. So I have certainly, being an advocate, drawn that inference from it, and I believe it's a correct inference under the circumstances of this case. I'm out of time again. Very good.
Thank you, Mr. Manus.
Thank you, Your Honors, and
Ms. Rubenfeld. Thank you too. Ms. Kraft, would you adjourn court?
This Honorable Court of Tennessee is now in recess.